Hello, everyone, and welcome back to the Employment Law Counselor Podcast. I'm your host, Jeff Stewart, and each and every episode, we tackle the laws and regulations that make up the world of labor and employment law. Today, we will be covering the interesting world of employee handbooks. As always, I'm joined by one of my colleagues here at White & Williams to discuss our topic of the day. Today, I'll be joined by Laura Corvo, who practices out of our Newark, New Jersey office. How are you doing today, Laura?
I'm doing great, Jeff, and I'm so happy to be here with you.
Well, thanks for joining me. I'm looking forward to this because we certainly get a lot of questions about employee handbooks.
I'm sure.
So let's dive right in, Laura. I mean, when you're talking to a business owner about an employee handbook, do you get the question, hey, what even is an employee handbook?
I do, and it's a great question. And an employee handbook is really a guidebook for employers and employees that kind of defines their relationship. On the employer's end, it tells the employees what to expect from the job and what the employer is going to expect from them. And on the employee's side, it lays out what they're going to expect from the employer, what benefits they're going to get, when they're going to get paid, are they going to be eligible for vacation, sick leave, all that type of stuff. And it's just a way to have it all out there in an easy, user-friendly way that kind of just explains how this relationship is going to work.
Absolutely. And I always tell employers, this is kind of the introduction to the company that you give employees when they first start, what to expect, what you expect of them. Again, that setting clear expectations at the beginning of a relationship is so very important when you're talking about what you hope to be a long-term employment relationship.
Right. And it's not just used at the beginning of the relationship, it's used throughout. And I think a lot of employers forget that. And employees, they put it in their drawer and never, look at it again. But, throughout the course of the employment, you're going to want to know different things that are going to be in there. Are you suddenly eligible for a 401k plan? What does that mean? Where is that going to be found? Are you, is there a disciplinary process that you need to go through as an employer? All of that's just going to guide you along the whole entire relationship.
Absolutely. And I tell employers when they talk to me about the importance of one, that I view the employee handbook as a shield. If an employee is going to bring a claim against you of some kind, this is your shield. This is what will protect you, because you can say, look, we followed our policy in this area. We did A, B, and C, just like we told you we were going to do A, B, and C. And, I'll be asked, well, when you say use it as a shield, where do you use it? I mean, for me, the most common that I see is obviously unemployment hearings. It is the most common issue you're dealing with an employee on the back end of the employment relationship. Usually you have fired them for violating a policy of some kind. If you go into that unemployment hearing, you're going to need to be able to show the policy and show this is what happened. And as a result, we took discipline and ultimately fired this employee. And that unemployment referee is certainly going to want to see that policy and your handbook right off the bat.
Absolutely. Be it unemployment or, further litigation, whether it's an EEOC claim or a lawsuit. Often in lawsuits or claims that are brought against the employer, the employee handbook is your exhibit A. It's the first thing that somebody's going to ask for. And certainly you and I, Jeff, as attorneys who defend employers in these claims, it's the first thing we ask our clients for. Where's your employee handbook? What does it say?
Absolutely. And I always talk to employers as well, because I think the employee handbook goes a long way to avoiding claims before they even occur. If an employee knows that they violated a rule that is well published, well known, they are less likely to bring a claim because they're less likely to think they're being picked on or they're being treated differently. In fact, that handbook, if it is properly drafted and followed, can avoid claims and save employers literally tens of thousands, if not hundreds of thousands of dollars.
Absolutely. The other thing it does is it ensures that if you have a policy and a procedure, you have a consistent way of applying things to your employees. So you're not kind of out there as an employer acting willy-nilly. You're not giving one thing to some employees and something else to another set of employees, which gets you into trouble, especially when it comes to discrimination claims. So if you're acting consistently, if you have a policy, if it says, everybody gets 5 days of vacation, and in order to get 5 days of vacation, you got to work for this many hours. That's a policy. It's there. You follow it. It allows you to, lay it out consistently, and then have something to fall back on when you do enforce it consistently.
Absolutely. So let's shift gears here a little bit, Laura. I want to talk about some of the essential policies that should be in any handbook, whether you have 1,500 employees or whether you have 15 employees. And I guess the first one that I want to talk about is an EEO policy, or an equal employment opportunity policy. Would you agree that that's one that should be in every handbook?
Absolutely. And it's probably one of the first policies you're going to see in most handbooks. And all that is a statement that really does two things. One, it says that the company doesn't discriminate against employees, either in their hiring, their promotions, or their terminations based upon any protected class, like race, religion, gender, ethnicity, etc. And it also says that the employer is not going to tolerate any of its employees engaging in that form of discrimination. So it's just a message out there that says we don't discriminate and we don't put up with discrimination. And it's an important statement for all employers to have.
Absolutely. And in fact, it also highlights something that I know you and I talked about offline as well, which is the importance of making sure your handbook is tailored to your company and where you do business, because there are different protected classes in different states. Many people may not know this. If they work in one state exclusively, they may not know that, for example, in the state of Wyoming, you are in a protected class if you use tobacco products. So smokers or people who use chewing tobacco are considered a protected class and cannot be discriminated against. Whereas in Pennsylvania, New York, New Jersey, where we practice primarily, you can absolutely have different policies for smokers or tobacco users, whereas in Wyoming, you can't. Well, if you have a business that does business across state lines, you're going to want to make sure your EEO policy not only lists those protected classes that are covered under federal law, but I always like to include a phrase or any other protected classification under applicable law. In other words, if my business would expand to a particular state that has a different protected class, we are going to recognize that protected class without the need to change our policy.
And that also extends to localities beyond states. So you may be operating in New York and have certain rules that apply to New York City that maybe don't apply to upstate. So if you have multiple businesses, depending upon the locality. So I always like to say applicable as well, or, state, federal, state, or local laws or rules, because there's a lot you can have fall into traps with regard to that.
Absolutely. That's why the EEO policy needs to be carefully drafted. So let's jump to the next one, which is that I think every employer needs to have, regardless of size or anything to that effect, and that is a harassment policy. And not only the prohibition on harassment, which you would think is kind of obvious here in this day and age, but specifically having effective complaint mechanisms. That is absolutely paramount in a harassment policy.
Absolutely. And a lot of employers come to me with the intent of drafting an employee handbook because they're looking for a harassment policy. And there are some federal and state cases that say if you have a policy that has an effective complaint procedure and your employee doesn't go ahead and file it, if an employee commits harassment towards a fellow employee and the employee who was harassed doesn't bring it to your attention, the fact that you have a policy and that they didn't follow that policy may give you a shield in a potential harassment claim. But one of the things I think when people hear the term harassment policy, they think about sexual harassment. That's what's most in the news. We heard a lot about it during in light of the Me Too movement. But harassment has to also encompass other forms of protected class. You could have racial harassment, harassment based upon religion, harassment based upon a series of protected classes. So you want to make sure that that policy states that. And you also have to look to state and local law because they say what should be in that harassment policy oftentimes. The harassment policy that, for example, New York requires may not be the same as a harassment policy in Pennsylvania or New Jersey, but you do need to have it. It is, I think, the most important policy to have in a handbook.
The next policy I want to talk about is drug testing policy. And really, this, I believe, is an absolutely perfect example of not every little detail needs to be in your employee handbook. Because when I think of a drug testing policy, I think of two different policies. One is what's in the handbook, which puts your employees on notice that they could be subject to drug testing, whether that be random, whether that be reasonable suspicion, post accident drug testing, but whatever form of drug testing an employer is going to utilize, they need to put the employees on notice of that. And that is normally through the employee handbook. Now, separate and apart from the handbook, an employer is going to want to have a full drug testing policy, which will really get into the mechanics of the testing. This is how we do a sample. These are the drugs that we test for. This is what happens if there is a positive, that we get a confirmed, and then it becomes a confirmed positive, et cetera, et cetera. And you identify your medical review officer. There's a whole litany of things that goes into a complete drug testing policy. But in your handbook, all you need to do is put your employees on notice. So the drug testing policy for a handbook, at least in the handbooks I draft, and Laura, tell me if you do it differently, is normally 1 to 2 paragraphs, putting them on notice of that they are subject to testing and when, but not the whole litany of the mechanics of the drug testing policy itself.
No, I absolutely agree with that. I think it's just a short statement to the employee that, hey, this is something that we might be doing. It's also something the employer has to think about. Not every employer is going to drug test, so they're not every employer is going to need that policy. But if it's a policy you're going to have, it should be in the handbook of the employee. It's your way to notice the employee that this may be happening.
Absolutely. Now, Laura, the next one I think we should talk about, or the next, I'll say, more broad category to talk about, is wage and hour policies. Because as you and I both know, because we deal with this on a daily basis, wage and hour claims have just skyrocketed really in the last 10 years. And, I've seen in the last 2 or 3 years quite an explosion, specifically in the class action, collective action, wage and hour area. And much like when we talk about EEO claims, your handbook is the starting point of any defense. Can you talk for a little bit about some of the key wage and hour policies that should be in the handbook?
Sure. And you're right. It is the first shield to your defense of a wage and hour claim. One of the things I always counsel employers on when we start to think about wage and hour, the first thing your employee is going to want to know is, when are they going to get paid? When's payday? There's wage and hour laws that say how frequently you have to pay an employee. Is it every week? Is it every other week? Is it monthly? Is it bi-monthly? That goes to state and local law. But you have to have that statement in there. When are you going to get paid? Employees want to know that as well. When's my paycheck coming? How's it coming? The other thing I always focus on is overtime policies. Now, under federal and most state laws, if your employee works overtime, you have to pay them regardless of whether or not you wanted them to work that overtime. In other words, you have to give them the overtime if they went over the 40 hours or whatever the overtime threshold is, even if you didn't want them to do that, as long as they perform the work for you. But with an overtime policy, you can discipline the employee if they fail to get authorization to work that overtime. So you can control the overtime through that policy. And I think that's a really important policy for employers to have. The other policy I always like to put in there is that if there's an inaccuracy in a paycheck, you want to ask the employee to let you know about it so that you can make the correction. If the paycheck's wrong, put them on notice to say, it's on you to tell us if something is wrong, if your hours were not properly reflected in the paycheck we gave you that week or that month.
And that's actually a really important one, because when the Department of Labor updated the Fair Labor Standards Act regulations in, I believe it was 2004, they specifically said, look, if you have a paycheck inaccuracies policy, we will allow a safe harbor. In other words, we're not going to have penalties, et cetera, as long as you have a policy and you follow it that says we will correct any inaccuracies by the next payday. So that's a very important policy that specifically was, I'll say, mandated, although mandate is probably not the right word, was certainly strongly suggested and encouraged by the Department of Labor. So the last set of policies I really want to talk about here are the remote work policies, which we've seen a lot in the last 2 years, obviously. What specific policies, Laura, are you suggesting to your clients that they make sure are in their employee handbooks?
Yeah. So if you have employees who are working remotely, you have to set the terms of what that remote work is going to be like. One of the hardest things to do with remote employees is control the times that they're working. And especially if you have non exempt employees who are subject to overtime laws, you don't want employees claiming they were working, all into the night, charging you exorbitant overtime rates. So you want to have a policy that says, if you're working remotely, this is how you have to log in and log out so that we can control it. So you want to have wage and hour policies within your remote work. You also want to protect your confidentiality. People are going to be working from their homes. They may have your confidential information. How is that going to be handled for the remote worker? You also have to think about workers' compensation issues. Even though if somebody's working from their home and a home office, if something goes wrong, if there's a safety issue, you could have a workers' comp claim on your hands. You want to regulate the safety of the remote workplace. There's a lot of things that go into that. So I think that's something employers really have to think about. And, a lot of employers shifted to remote work very quickly because of the, conditions with regard to the pandemic. But now that you've kind of had a chance to have employees out there for some time on a remote work basis, it's really a good time to put pen to paper to define what that remote work should be like.
Absolutely. The other thing that I've had a lot of employers ask me about with remote work is, you know, making sure that the employees know the expectation of their availability. If you are called, this is, we expect to return phone call within X amount, or we expect you to be at your computer between these hours so that you are responding to emails, et cetera, et cetera. I said that was the last policy, but there's actually one other I want to highlight before we move on here. And that is probably the most utilized policy when we're dealing with, whether it be unemployment or potential discrimination claims. And that's the discipline policy. I mean, nobody likes to think about disciplining employees, et cetera, but it is a necessary part of the employee handbook. And the thing I tell employers, and Laura, I'm curious to hear your standpoint on this. I imagine you tell them similar, is I want to have clear rules, but I want to have the level of discipline be something that as an employer you have discretion as to what level of discipline, because obviously if somebody commits the same offense over and over, I don't want them to think, oh, it's no big deal, oh, that's only a written warning. If they're going to flout a policy, I want to have the ability to do something more. So Laura, what's your feeling on discipline policies?
I agree with you, Jeff. I think that they're a necessary policy because you have to tell employees what's expected and that there may be some things that are going to lead to their discipline or even their termination if they get it wrong. But at the same time, you need to be flexible because you can't spell everything out. The employee is going to do something that's so obvious that maybe isn't in the handbook, but yet it's still something that you aren't going to tolerate. And you want that flexibility. So you have to carefully word those disciplinary policies to provide a non inclusive list of examples and a non inclusive list of potential penalties and how they're going to work so that you have that flexibility. Because no matter how hard we as lawyers try to think of every possible scenario, it's not achievable. And you have to have the ability to be flexible.
Absolutely. And just a short war story here, that I had an employer who called me up once since they wanted to terminate two people that they walked in on them, let's just say, in a compromising position in their office. And they said, well, we want to terminate them, but there's nothing in our handbook that says we can. I said, well, you don't need everything spelled out in your handbook. So, this is one that is so clearly outside the bounds of what you would expect from someone when they are on the clock. You're good to fire them. And certainly they did. So, but you're right. You cannot possibly predict every crazy thing that an employee could or would do. So, the key in discipline policies is having that flexibility.
Absolutely.
So let's spend a couple of minutes here. I want to talk about the most important part of the handbook. And I think you and I would both agree that if there is one thing that is most important in the handbook, it is that last page, the acknowledgement page. Can you just tell our listeners when we say the acknowledgement page, what we're talking about?
Sure. At the end of each handbook is a statement that the employee is going to sign off on that basically acknowledges that the employee received the handbook. I like to say that they received, read, and understood the policies within the handbook. And that's really going to be your exhibit, your ability to show a court, an employment officer, or whoever is, you're defending a claim against, that the employee had the policy, was on notice of the policy, and then their failure to then follow the policy once you've established that knowledge is going to sink the employee. So absolutely important. And I, talk about war stories. I many times the employer will produce a great handbook. It'll have wonderful policies in it. And then I will say, where is the acknowledgement page for this employee who is bringing a claim against you? And the employer will be like, humana, we never got the employee to sign off on it. Well, as great as that handbook is, unless the employee signs off on it and acknowledges it and you retain that acknowledgement, it's not going to do you much good.
Yeah. And as a general rule, those acknowledgments should be signed, dated, and kept in the employee's personnel file so that you can grab it for that employee. And if you have not done it to this point, employers, I tell them, you know what? Once a year or so, they should do a review of every employee personnel file and make sure some of the essentials are there, which includes this acknowledgement. And if it's not, make sure you get it signed because it is that important.
Absolutely. And actually, I like to also in the acknowledgement page have the employee acknowledge not only that they read and received and understood the handbook, but then also cite to some of the specific policies that you are most likely going to be getting sued on a harassment policy, wage and hour policies, social media policies, confidentiality policies, things that you think might come where the employee may either file a claim or may be disciplined on. Just highlight them in the acknowledgement page, have the employee check off on them that they acknowledge them. And I think that's a great shield to have for the employer.
Absolutely. Now, the other thing is when you update that handbook and when let's say you redistributed a handbook because you've made some major revisions, you should have employees sign a new acknowledgement every time you do that. So if you have a 10, 15-year employee, you may have 4, 5, 6 handbook acknowledgements in their personnel file, and that's okay. And frankly, that's ideal. You want to have that acknowledgement every time you reissue that handbook.
Absolutely. I think the more acknowledgments you have, the more times you can show someone that you continue to revisit this issue with the employee, you continue to put it in front of them and have them sign off on it, the better off you are. You don't want to have a situation where, you have somebody who worked for you for 15 years, got an employee handbook at the beginning of the relationship, and then they never heard back from you on any of these policies since that time. It should be something that's regularly updated.
Absolutely. So let's talk for a few minutes here on some practical tips when creating an employee handbook or drafting an employee handbook. Well, let me ask you this. What is the ideal size for an employee handbook in your eyes?
Yeah, well, I think the shorter the better. Around, I would say 25 to 30 pages is ideal. Sometimes it's, for a smaller employer, it might be as short as 10 or 15 pages, but it's not a treatise. It's not Gone with the Wind or, a huge booklet that the employee has to go through. It should be short and sweet and actually plain and simple. One of the things I think a lot of employers make a mistake with is they, try to regurgitate the law when they're drafting their policies, citing to statutes, and they're citing to cases and legal things. It's not a legal treatise. It's a handbook for employees, so it should be plain and simple and direct, and I think just straightforward.
And I think the other thing is that not everything needs a policy. I tell people this story. I had a client once who every time something or there was an issue with their workforce, they wrote a policy. And in fact, in their handbook, they had a policy on food in the refrigerator and how long it could be there and that it needed a name on it. And at the end, their handbook, when they gave it to me, was 137 pages. And I said, who in the world would ever read this? And my client's response was, well, it's meant as a reference, not really to be read. But if you need something, you look there first. And well, we changed that, and we got their handbook down to about 20 pages because it was just that was so far on the other end of just not being readable. And if it's not readable, it's not useful.
Absolutely. And I agree with that. It does not need to address every possible situation. It's really just the big things that you want to highlight with the employee, the expectations you're going to deliver, and the things you're going to expect from them.
Absolutely. And there are certain policies that absolutely should be objective. It is very clear if this happens, then it's this. But there are other areas, specifically in the discipline policy, where I like to draft policies that keep the discretion in the employer's hands. That they can deal with the actual what happened here and deal with it what they believe to be appropriately, because when you're dealing with discipline, there is no one size fits all.
Absolutely. And I think you also have to keep discretion, kind of throughout the policy, including the discretion to change the handbook. I like to put a statement at the beginning that, the employer reserves the right to make changes to this. You may decide to change your vacation policy and, either shrink or grow the number of vacation days you're offering an employee. You have the right to do that as an employer. And you don't want the employee handbook to become so specific that it's creating a contractual right for the employee. It should give you the discretion to change things, the discretion to set the relationship tone, et cetera. So, yeah, I think that it's very important to leave that discretion in the employer's hand throughout the employee handbook.
All right. So, Laura, I always like to give our listeners a few takeaways from our episode. So, as we start to come to our close here, let's talk about a couple of takeaways on handbooks here. And I guess I'll start. And the first takeaway that I have for people is that handbooks are a must, but they must be done correctly. If you don't have that acknowledgement, for example, well, there's no point in having it. If you have that 137-page handbook that no one actually reads, that doesn't help you as much. So handbooks are a must, but they must be done correctly. How about a takeaway from you?
Sure. I think the other thing that handbooks do is they give employees a chance to kind of stop problems before they start. They allow you to set very clear expectations as to what, you're expecting from your employees, what you're going to deliver to the employees. It's a great way to communicate with your employees, to set the expectation of that relationship and to kind of just serve as a guidance as to how that relationship is going to occur over the course of time.
And I guess the last one I'll throw that is, you know what? A little time and money spent on an employee handbook can literally save tens of thousands of dollars if it helps to avoid even one claim. And if it avoids 10 claims, well, let me just say you are saving hundreds of thousands, if not more, dollars, because any claim you can avoid is money well spent.
Absolutely. Invest a small amount of time now, and you'll save a great amount of time in the future by developing a handbook.
Absolutely. Well, I want to thank you for joining me here, Laura. I know we have lots more to talk about employee handbooks. And in fact, we're going to do another episode on common mistakes in employee handbooks. But for now, I want to thank everyone for joining us here on the Employment Law Counselor podcast, where we try to make sense of the world of labor and employment law. On behalf of myself, Jeff Stewart, and Laura Corvo, we thank you for listening. If you enjoyed the episode, please leave us a 5-star review, tell your friends, and subscribe to the podcast. For more information on this and many other topics, please visit our blog at www.theemploymentcounselor.com. Until next time, stay safe and stay compliant.